In each of these matters, Mr. Perkins is here today after failing to appear before this court on July 20th, 2022. In the first case, bond is currently set at $1,931. In the second case, bond is currently $500. This is the sixth bench warrant in each case. He reports that he is employed at TSC. Last payment made on these accounts was in April of 2022. The court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on August 9th, 2023 at 8 a.m. before this court.
Mr. Perkins, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on August 9, 2023 at 8 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Yes.
Okay.
Yes.
How much money do you have that you could post?
I don't have any on me.
Okay. I assume probably you didn't, but
You said I hadn't paid since when?
you have not paid since April of 2022.
Any other time I have a job, they take it out right out my check. So
Well, they only take it out of your check if they know you have a job. So if you didn't notify them, then they would not be taking it out.
I notified them. I gave them my job number, my address. Yes, I have. She could tell you. I gave her my job, my name, the street the job was on, and everything. So
Okay.
Any other time she'd just find out I'm working and take it out.
Okay. Well, they can't just find out. So
Anytime I've been working since I've been working down here in old child support, I get 2 checks maybe, and then the next check they start taking out.
yeah. Well, I don't know.
So I don't know what's the problem this time. And then she had my number. So if she wasn't getting paid, why wouldn't she call me? She called me to update my address and stuff.
I have no idea, sir. Well, you do have 6 prior bench warrants. And again, the court's taking that into consideration as well as the non-payment of well over a year.
I really thought they was getting their money.
What?
I really thought they was taking out my check.
Well, all you have to do is look at your check and see if they don't show that there's a front of the court deduction, then they wouldn't be taking it out of your check. It's pretty easy to determine that.
Well, when you get paid on a card, you can't see what's taken out.
Well, what I'm going to do is I'm going to reduce your bond in hopes that you could be released pending that hearing. I'm going to set your bond in both cases in the amount of $250. So if you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. Your excuse. Have a good day.
Ms. Coy is here today after failing to appear before this court on March 15th, 2023. Bond is currently set at $504. This is the 7th bench warrant. She reports no employment. Last payment made on this account was in March of 2023. That was a $500 bond forfeiture. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on August 9th, 2023 at 8:45 a.m. before this court.
Okay, thank you. Ms. Coy, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on August 9, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
No, sir.
Okay. Well, court does note that it is your 7th bench warrant and we haven't had any payments since March. So the court's taking all of that into consideration in this matter. What I'm going to do is I'm going to reduce your bond in hopes that you could be released. I'm going to set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay. Thank you, ma'am. Your excuse. Have a good day. Good morning to everyone. Court has been advised that we do have a consent judgment in this matter. I'll just clarify with you, Ms. McMillan, you have signed the consent judgment in the UCSO. Is that correct?
Yes,
And so you're not disputing and you're not contesting anything.
correct.
Okay, thank you. Mr. McMillan, we're going to have you sworn in. If you'd raise your right hand and then we'll proceed.
Sir, do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
Go ahead, Mrs. Capture, when you're ready.
All right, thank you. Can you please state your name and spell it for the record, your full name?
Robert James McMillan, ROBERT JAMES. Excuse me, MCMILLAN.
And Mr. McMillan, what is your present address? And did you
1
live at least 180 days continuously at that residence in Michigan before filing this action?
Yes.
And is that residence currently in Calhoun County?
Yes.
And did you live there at least 10 days continuously before filing this action?
Yes.
And were any children adopted, born, or conceived during this marriage?
Yes.
And what is the name and age of that child?
She's 5. Joey.
And is your wife currently pregnant?
No.
And when were you separated?
December 3rd.
Of 2022?
Yes, ma'am.
And do you know where your spouse currently resides?
Yes.
And what is that address?
I don't know.
Okay. You state in your complaint for divorce that there has been a breakdown of your marriage to the extent that the objects of matrimony have been destroyed and no reasonable likelihood remains that your marriage can be preserved. Is that statement still true today?
Absolutely.
And can you describe briefly to the court the facts on which you base the statement?
Marriage is just dissolved.
Okay. And do you think there's any possibility of reconciliation?
Not at this moment.
There was a proposed judgment of divorce that is a consent. Did you sign that?
Yes.
And did Ms. McMillan sign that?
Yes.
And have you had an opportunity to read and do you understand the property settlement agreement that was placed in that consent judgment?
Yes.
And do you believe that the terms of that agreement are satisfactory to you and equitable?
Yeah.
And there is a custody arrangement in this matter and a uniform child support order. Do you believe that is in the best interest of your child?
Absolutely.
All right. Thank you, Your Honor. I have no further questions.
Court is satisfied that the testimony does establish a statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will enter the consent judgment and the UCSO as agreed upon and signed by both parties. That will conclude your case. You are divorced. Best of luck to both of you, and I hope everything works out. The court will end this hearing at 8:41 a.m. You're free to go. Have a good day. Mr. Cureless on behalf of the plaintiff and Mr. Clay on behalf of the defendant. There are two matters before the court, the plaintiff's motion for supervised parenting time and front of the court investigation and defendant's motion to show cause. Ms. Cureless, I'm just curious, you referenced in the motion an affidavit, but the affidavit doesn't explain what happened to cause the involvement of CPS, so the court has no idea what you're alleging.
The minor child did reveal to the mother, Miss Bordeaux Phillips, what had happened between Mr. Phillips and the minor child. We had believed that CPS had also revealed this to Mr. Phillips. Part of the discreetness, Your Honor, is we didn't want to start making accusations that if the child is returned to Mr. Phillips, that there would be some acting out and cause a breakdown of that relationship until this is further investigated by friend of the court. When the CPS report does come out, I'm sure friend of the court will have all of that information. So that is the reason why the affidavit was not more forthcoming.
Okay, well, I understand that, but you do have due process notice requirements, and hopefully the defendant is able to figure out from the fact that there's no information provided that what they have to defend and respond to. So I guess I'll ask Mr. Clay. Mr. Clay, were you in the same quandary the court was, or did you have more information?
Yes, Your Honor. I'm confused on what the alleged allegations why supervised parenting time would even be necessary when the CPS investigation made recommendations that Mr. Phillips be supervised with his fiance. Yet we want to change that to a third party. without any other allegations that have already been cleared by CPS.
Okay. Ms. Kearless, enlighten us, why with, we have CPS saying, recommending supervised with, with the defendant's significant other, why should we change that?
The allegations that were made by the child to his mother, the time period happened when Mr. Phillips was dating Shelby, his fiance girlfriend that he's currently living with. The concern is that she would be biased and not neutral in the supervision, considering the allegations happened during the time that those two were seeing each other. So that would be the reason why we would be requesting a third-party supervisor. And Your Honor, Ms. Shea, Ms. Bordeaux would be willing to share some of the details with you this morning, if that would help you make a decision.
Well, I guess without any information whatsoever, the court's at a loss. I don't know how I'm going to decide a motion when I don't know anything that happened, or, you know, we don't have any reports from CPS or anybody else. So I guess you just have the court guessing at what the basis for the motion is.
Well, at this point, Your Honor, the fact that CPS is and the Battle Creek Police Department are recommending supervised visits and a recommendation to the front of the court to further investigate this matter, we do believe that supervision is necessary. Again, the reason why we did not want Shelby, his girlfriend, to be the supervisor is because she happened to be with Mr. Phillips at the time of the allegations. Furthermore, I'm unsure how she can properly supervise if their work schedules, you know, are different. And Mr. Phillips would be with a minor child unsupervised during her work schedule.
Okay, well, I don't know. Mr. Clay, again, it's very nebulous, but are you able to respond at all?
Your Honor, if the plaintiff's unable to share with us what these allegations are for us to properly defend these claims, I don't see any reason why we shouldn't just follow the CPS recommendation.
Okay. That's fine. Mr. Clay, do you wish to proceed with your show cause?
Yes, Your Honor. So on May 29, CPS began an investigation on the defendant. Following that investigation, they since lifted a safety plan. I think the plaintiff was informed on July 5th of these recommendations that safety plan be lifted and Mr. Phillips be able to supervise a minor child with his fiance. Since that time, the plaintiff has alienated the minor child from the defendant. And I think that's a violation of the parenting order that was set. And due to the plaintiff unwilling or unable to show any circumstances beyond what CPS had investigated that show no cause, we find that the plaintiff should be held in contempt of the order and grant the defendant make-up parenting time of no less than 2 weeks that he's missed.
Okay. Ms. Kearless, your response.
Parties had been exercising a 2-2-5 schedule, and then they decided to do a week on, week off during the summertime. And I think that that's something that's possible during the school year as well. However, the reason why Ms. Bordeaux did not return the minor child after the expiration of the temporary custody arrangement by CPS that she not allow visits with Mr. Phillips expired on June 30th is because of the supervision issue and true fear of returning the minor child to the father, considering what has happened. Again, Ms. Bordeaux is willing to share those details with you this morning in court, Your Honor, if you would like to hear those, but that is the reason why she has kept him. Also, that is the reason why we filed our motion, because we know that this needed to be worked out to determine what parenting time should look like, what supervision should look like. So if there is any makeup time, we would request that, because they have been doing week on, week off, that it be in blocks of Mr. Phillips having, during the week, and Miss Bordeaux having every weekend until those 14 days are made up,
Okay,
but that she not be found in contempt.
okay. Mr. Clay, is that agreeable that they can alternate the weeks, but she'll get the weekends, and then your client would get the time, basically the 5 days through the week to make up until we make up apparently the 14 days.
Without speaking to my client and deciding what he wants to do, I would reject that at this point.
Well, what we'll do is, you can talk to your client outside of court and make arrangements at that point. What the court is going to do in this matter is the court, at least on the contempt issue, the court will reserve on that pending evidentiary hearing. But it's been offered that there's by the plaintiff to give the 14 days makeup, so the court will order the makeup of 14 days, and I'll leave it up to the parties to communicate and see how they're going to accomplish that. And that way you've got some flexibility based on schedules, et cetera. What the court's going to do as it relates to the supervised parenting time is the fact that the court has very little information in this matter to make a determination, but as Mr. Clay stated, he was agreeable with, again, the recommendation, if you would, of CPS for supervised parenting time. So what the court will do is the court will follow and adopt the CPS recommendation as it relates to parenting time in this particular matter. So that will be what we'll do as we proceed further. Mr. Clay, what's your response as it relates to the need for a front of the court investigation?
Your Honor, at this point, I believe that we had CPS, Battle Creek Police Department, Emmett Township, all conduct an investigation with no findings. I feel like a front of the court investigation is unnecessary.
Okay. Well, I think that at this point, the court doesn't see that there's a need. If we have an evidentiary hearing, we'll be able to get everything out at that particular time. So I'm not going to order a front of the court investigation at this point. I'll ask that both of the attorneys would prepare their respective orders, submit them under a 7-day notice of entry. And that will conclude this matter at 9:12 a.m. You're free to go. Have a good day. Court will note the appearance of Mr. Toth on behalf of the plaintiff, Mr. Bartell on behalf of the defendant. This matter is before the court on the plaintiff's amended motion to enforce consent order as regarding the authorization release of the passport. Mr. Toth.
Thank you very much, Your Honor. I think both parties agree on one thing. It's that the approval of both parties is necessary for either party to take the minor child out of the country where a passport for that travel would be necessary. And that's why we're here today. Your Honor, the minor child is 10 years of age. My client desires to travel with her to Japan from November 17th through November 26th. This will not interfere with Mr. Gardner's parenting time. The purpose is to enjoy a gift that was provided to both Amy, the 9-year-old, as well as my client, of 4 days at Tokyo Disneyland and a place known as Mario World Universal Studios. From what I understand, this Mario World Universal Studios is the only one in the world. Mario World is perhaps much like Harry Potter was to my kids. It's something that is attractive to young children everywhere, and that's the purpose of going. It's a vacation, and it was a gift. Your Honor, the objection in this case fails to identify any facts that would suggest that my client intends on somehow kidnapping the child and leaving forever. There's no evidence supporting that. There's many factual claims that are totally irrelevant to what we're talking about. I think what we're talking about here, is there any evidence that would suggest that my client has any ill plan to do something with the child? But there is no evidence supporting that. My client has been a citizen of the United States for 10 years. She's worked at Eurofin's lab as a senior chemist for 6 years. She owns her own home in Battle Creek. She has lived here for an extended period of time, and there's simply no evidence of any intent to do anything but go on a vacation. And Your Honor, I think it's a reasonable request. Mr. Bartel, in his answer, made some notion about the previous request to go to Thailand, and I did not represent my client at that hearing, and an associate did, but I did look at the video shortly thereafter, and I believe the basis of that ruling was simply that there was no specific plan. In other words, there was no particular dates or particular time or particular anything of my client's desire to go to Thailand, and I believe that was the court's basis. This is far different. My client will provide an itinerary. There'll be the ability to have telephone contact if for whatever reason it was necessary. And I believe that, Your Honor, again, this is a situation where there ought to be some evidence to suggest somehow that there is an ulterior motive here. Thank you.
Okay. Mr. Toth, if your client does go to Japan, she has the passport, what's to keep her at that point from simply going to Thailand?
Well, Your Honor, the answer to that would be nothing. And then I guess the answer would be she's not allowed to go anywhere. She could go to Windsor, drive to Toronto, and get on a plane and go to Thailand. Your Honor, the answer to that is nothing. Okay. There is nothing to prevent anybody from getting on an airplane in anywhere in the world with a passport and going to Thailand.
Okay, Mr. Bartel?
Yes, Your Honor. And before I get into my stuff, the issue here is obviously the passport for the minor child. And if that's not released, then obviously the plaintiff can go, but the minor child can't. So I don't think plaintiff's response was really responsive to your question. But interesting here, Your Honor, there's a few different things that I would point out. Number one is the timing of this matter. After this court denied the motion to go to Thailand, all of a sudden on June 2nd, we receive a letter saying, well, now she wishes to go to Japan. Plaintiff has no connection to Japan. Plaintiff's daughter has no connection to Japan. And it's interesting, Your Honor, in their motion, they never referenced this now taking the minor child to these different universal parks that are so important now. Yet, just in the motion, they just say we wish to go there. And then, as Mr. Toth pointed out, at least from their version, is the court had concerns about no itinerary, but yet they still don't put anything in their motion about detail. And the reason being is if you look through paragraph 4 through 6, all they're referencing in there is still plaintiff's father. And so I think this is an end around, Your Honor, to go to either Thailand or really some other reason that we don't know. It just doesn't add up. Also, Your Honor, plaintiff will be taking the minor child out of school. She will at least be missing 3 days of school. We do indicate the history of the parties here, Your Honor, because it is important. It's important because plaintiff has not filed court orders in the past. And I don't need to detail all that. We provided it to the court last time, and the court, I think, took that into consideration as well. But she doesn't file the court orders, including going to counseling that was ordered by Judge Yost Johnson when she had the case for a little bit. And yet she wants the court to believe that she's going to follow all the court orders otherwise. We did attach, and it may seem small, but we attached a text message around Mother's Day where she agreed to do a pickup and drop off. Then she forces my client to go back and pick up the minor child. See, she can't even follow simple agreements or orders, Your Honor. And there is nothing to prohibit her from going to Thailand or keeping the child if she's allowed to do this. If the grandparents, which, like I said, look through paragraph 4 through 6, I think that's the reason really here. If she wants them to see the grandparents, they can go to Washington. I don't think it's appropriate for this passport to be given to plaintiff, given her history. And as the court did note, there was no connection for about 8 years between the grandparents and the minor child. I think at the end of the day, Your Honor, this should be denied, given the lack of information provided by a plaintiff and the circumstances here. Thank you.
Okay. Mr. Toth, any reply?
Yeah, yes. Yeah, as a matter of fact, yes, Your Honor. I don't know how we can get more specific as to where she's going, when she's going. They're taking an airplane there. The whole factual claims of my client not following court orders, that's not before the court today, and that would be a contempt hearing. And my client, well, we would challenge those facts and those representations. Your Honor, effectively, I think what the position of Mr. Gardner here is that my client should never be able to take the child out of the country. It makes no sense. There is no evidence that my client would have any intent or any plan or any history to try to remove herself and the child from this country. It's totally illogical. She's as connected here as anybody is. And the fact that she wants to go to Japan, the fact that she wants to go to a park that exists nowhere else in the whole world, to somehow suggest that's not good enough, or if it were Disney World France, would that be better? If it were going to Toronto to see Beauty and the Beast, would that be different? So, Your Honor, there's just no evidence supporting these claims. It's 100% speculation, and the motion should be granted.
Okay, thank you. Well, what the court does note that the case does have history, and one of that history is the court had to deal with just previously, with a very short time ago, with the request to have the child travel to Thailand, which the court denied in this particular matter. I do note that, as Mr. Toth acknowledged, that if we do release the passport and she's in Japan, there's nothing to keep her from going to Thailand. And not to say she would, we're speculative, but there are concerns in view of the first motion in this particular matter. What happens, the court in this case is going to deny the request to go to Japan. Further, I have some concerns in that the prior court order provided that the passport would be held in escrow and released upon agreement of the parties, be held by a plaintiff's attorney. I don't want there to be an issue where there's a claimed release or somebody believes that there's a release. I'm going to change that order to provide that the passport would only be released upon a court order. So at this point, I'll ask Mr. Bartel if you would prepare that order consistent with the court's ruling in this matter. And we'll end this matter at 9:26 a.m. Mr. Vanderhorst on behalf of plaintiff and Mr. Boucher on behalf of the defendant. This matter is before the court on the defendant's motion relating to temporary matters. Mr. Boucher.
Your Honor, I believe the court's in receipt of my motion regarding the temporary matters. I've had a chance to speak with my client prior to the filing and after the filing. Situation here, we have a just over 8-year marriage. We have 3 children. I believe 11, 8, and 3. Maybe off on that. I believe that's correct. Parties were residing together at, I don't want to call it a marital home. It wasn't a rental either. It was plaintiff's brother's home, I believe. Improvements were made, adding additional bedrooms, so forth. But at this point, I can't really comment on that. Discovery is due by the 2nd, this upcoming Wednesday. I have not received a domestic relations verified financial form from the plaintiff yet either, but that is not due until Wednesday as well. Ultimately, Your Honor, we have a situation where, my requests are straightforward. The parties are living quite a distance away from each other. The children were historically going to, I believe it's the Penfield School District. My client is looking to have them be allowed or ordered to enroll in the Pinconning School District. My client was the day-to-day primary caregiver of the minor children. Plaintiff has had a history of alcohol abuse. I think it led to the detriment of the marriage. He does not have a driver's license. Interestingly enough, plaintiff indicates that he has 15 or 17 people that can drive him. I've never seen it worded that way, but nonetheless, he's not going to be capable of getting the children to school, from school, or to extracurricular activities without the help of other individuals, and that cannot always be guaranteed. Ultimately, Your Honor, I just spoke with my client. There was, I appreciate the court's patience on this. There was confusion because there is a 1 o'clock or 1:15 status or settlement conference here this afternoon. My client had a little bit of confusion. She has appeared. Upon speaking to my client, she has been indicated by the children, again, 11, 8, and 3, prior to today's proceedings, that dad has told them about this case and has told them that, don't worry, daddy's going to win on Monday. That is a major issue. I'm asking for some temporary orders in place, specifically no abusive or threatening behavior in front of the children. Further, no disparaging comments about either parent in front of the children. Additionally, no discussion of this case in any manner whatsoever. You should never be telling a child that daddy's going to win or mommy's going to win. My client has not discussed this matter. Plaintiff has with the children, and that is not their problem to deal with. Additionally, Your Honor, because school is approaching here shortly, and my client has historically been the day-to-day primary caregiver. She's been responsible for the children's schooling on a regular basis. She has not violated any orders, not that there are really any orders at this point, but has not overstepped her boundaries when discussing this with the minor children. And the fact that plaintiff does not have a driver's license, has multiple OWI convictions. I understand that he may be attempting to get his license back, but there's a lot of stipulations that come with that. AA attendance, substance abuse evaluations, counseling, and I have not seen any indication that he's taken any step whatsoever. So to indicate he's trying to get his license back is fine, but without those extra efforts, which I don't believe he's taken, it's going to be fruitless. I handle those on a regular basis. He's not going to get his license back. But that's neither here nor there. Ultimately, we're asking the court to allow us to, or my client, to enroll the children in Pinconning schools. She is more than capable of being responsible and making sure the children are on time, are not tardy, are at school every day, as she has since the parties separated. The separation was May 19th of this year, Your Honor, 8-year marriage. And she will certainly ensure that they are at school on time, their grades are kept up, and so forth, as she always has. I'm asking the court to take that in consideration, given that it is July 31st and school starting here in three and a half weeks. Thank you.
Thank you. Mr. Vanderhorst?
Thank you, Your Honor. Parties separated in May of 2023 when the defendant left to move in with her boyfriend that lives 164 miles away from the plaintiff. Prior to defendant moving to Pinconning, Michigan, the parties resided in Battle Creek for 5 years. The minor children were enrolled in Penfield until last week, when it's believed that defendant mother unenrolled the children in Penfield schools and enrolled them in the Pinconning school district. Penfield schools are set to begin on August 21 of 2023. Parties are currently exercising week on, week off parenting time, exchanging the minor children on Thursdays in Perry, Michigan. Plaintiff father would like that to continue. The children have attended Penfield schools for the last 5 years. The minor children have only attended Penfield schools their entire educational career. Minor child Emma is participating in soccer, and the minor child Hank is signed up to start football. Minor children have friends in the area and do not have any friends in the Pinconning area. The plaintiff father can provide a safe and stable environment for the minor children as he has their entire lives. Plaintiff father would like the children to continue with the school they have been attending the last 5 years and continue to reside in the home that they've also been residing in the last 5 years. Plaintiff is concerned where the defendant is living. It is believed she was residing in a home owned by her boyfriend's father. Plaintiff's father is concerned with minor children's living arrangements while in defendant's care, such as being in an overcrowded home. Also, plaintiff believes it to be in the children's best interest to not be exposed to any significant other while the divorce is pending. Plaintiff father works as a carpenter. He does have sufficient child care and transportation for the minor children. As stated, he does not have a driver's license. He does not drink alcohol, and he has 15 licensed drivers, friends, families, and neighbors that are willing to drive the children to school and any extracurricular activities. A main point is the children ride the bus to school, so that would not be an issue for him getting the children to school. Plaintiff does have concerns about the defendant's marijuana use. He has personal knowledge of her consuming it while the children are in the car. He would like a mutual prohibition ordered that neither party consume alcohol or marijuana while it is their parenting time. Plaintiff believes that defendant was employed at Amsterdam Medical Cannabis and Recreational Weed Dispensary until last week, where he believes she potentially no longer has a job. So defendant is asking for the children to move up to the area where the children have no contact. She has no stable home. It's her boyfriend's father's home. And also the children don't have any friends or activities in the area. So plaintiff father does not see how it's in the children's best interest to order them to an area they're unfamiliar with, where they have stability, friends, and activities in Penfield area. Plaintiff is requesting that he receive physical custody and the parties share joint legal custody. The minor child continued to attend Penfield schools they have for the last 5 years. No alcohol or marijuana provision be ordered. The minor child should not be exposed to any significant other while the divorce is pending. Each party pay their own attorney fees with child support paid to plaintiff. Thank you, Your Honor.
So, Mr. Vanderhorst, you said that the parties are meeting in Perry, is that it?
Correct, Your Honor.
Okay. And, Mr. Boucher, is there any problem with continuing them to meet in Perry?
No, and Kristen, did you hear that? Has there been any issue with that exchange in Perry?
No.
No, no issue, Your Honor.
Okay, thank you. Well, the court does note that, as set forth in the motion and is the defendant's response, that the children have been with the defendant in this matter since May 19, 2023, before they started alternating parenting time in the summer. What the court is going to do is the court is going to grant temporary custody in this matter to the defendant. Court will order support consistent with the support guidelines. The court would grant to the plaintiff standard parenting time. The parties would continue to meet at Perry at a halfway point. Neither party would consume alcohol, marijuana, or illegal drugs when the children are in their respective care. And the court would order that neither party would discuss the case or any of these proceedings with the children at any time. With that, I'll ask Mr. Boucher if you would prepare that order and submit it under 7-day notice. That will conclude this matter at 9:40 a.m. You're free to go. Have a good day.
Your Honor, can I ask one additional question?
Sure.
When the court says temporary custody, is that physical and legal, or is that?
Yep, I didn't differentiate, so it means total custody at this point. Yeah,
I will-
thank you. The appearance of Ms. Jordan on behalf of
Thank you, Your
the
Honor.
defendant in this matter. This matter is before the court on the defendant's motion for modification of custody, parenting time, and for an expedited hearing. Ms. Jordan.
Good morning, Your Honor. Attorney Sydney Jordan here with the defendant, Stephanie Hedrington, formerly Stephanie Jones, who is also present in my office with me. And I do apologize if there's any interference. We're trying to deal with technology here, so hopefully you can hear both of us and see both of us.
Okay.
We would just, point out all the allegations that we presented in our motion. The living conditions at plaintiff's home are subpar at best. In fact, he is living with paternal grandma at this point. There are some issues with paternal grandma as well. We have very serious concerns about the toxic and filthy environment that these children are subjected to during plaintiff's current parenting time. In addition, there are some issues and concerns regarding school. Harley, the youngest, is going into 3rd grade this year. She is okay. Harley, though, has been struggling in school more so than the older two. My client has put her in tutoring and summer school, both of which the plaintiff is aware of. However, plaintiff pulled Harley from summer school last week for a vacation, which is not in Harley's best interest. She really needs this extra help and this time this summer so that this school year goes better than previous school years have. In addition, when this summer school form was sent home, plaintiff did not note this vacation. My client was aware of it, but the summer school was not. When school folders come home, the plaintiff doesn't go through those folders. He doesn't read with Harley, although it's recommended that she get more help outside of school. We have concerns about attendance for all 3 of the girls. And frankly, Your Honor, the 2 oldest girls, one's going into 7th, one's going into 9th grade. These are tough years. These girls do not want to go to school reeking of animal urine and dirty and hungry. And unfortunately, these are a lot of the things that my client has to combat when these girls come home from parenting time with the plaintiff. When parenting time was changed back in 2021, the plaintiff was more stable, but that stability has gone by the wayside. He is not holding steady employment. He does not have adequate, sufficient, clean housing to support parenting time with these girls right now. In addition, the girls speak up and they tell the plaintiff, we're not comfortable being in this environment. We don't like to smell bad. And when faced with these, concerns of the children, plaintiff's response is, well, if you don't come with me, your mom's going to take me to court and take custody. These children do not need to be involved in the matters of this court. They are children and they deserve to be children. The two oldest girls should not be responsible for raising Harley when on plaintiff's parenting time. So, Your Honor, we would just ask for all the relief set forth in our motion, and that something be changed soon. You know, school year starting, we have very serious concerns for these children at this time.
Okay. Well, in this matter, the court does note it's 9:45 a.m. The plaintiff has not appeared, nor has he filed an answer in this matter. So the court does know in reviewing the pleadings that there are sufficient facts set forth in the pleadings to meet the Vadbarka threshold for an evidentiary hearing. The court is going to refer the matter to the referee for a hearing on the issue of custody parenting time support, and you should be contacted by the referee here shortly. I will tell you, unfortunately, just based upon schedules and that, the referees, as is this court, have substantial amount of cases, and so the chance of getting expedited are not substantial, but all I can do is once the matter is assigned to a referee, maybe you can contact the referee and get into some time slot that might get the matter in sooner, but that's all we can do at this point, because again, all of us are busy and have hearings scheduled quite far out. So that will be the order of the court, and we will refer it to the referee for that evidentiary hearing, and we'll conclude this matter at 9:46 a.m.
Smith, on behalf of
the plaintiff,
Thank
Ms.
you, Your
McNiff, on
Honor.
behalf of defendant. This matter is before the court on the defendant's motion to hold plaintiff in contempt for violating parenting time. Ms. McNiff.
Your Honor, the only things that I would add to our motion is that on July 16th, when mom indicates that she tried to bring Grayson back and nobody was home, there were people in the home. In fact, the home has cameras, security cameras, and my client has indicated that mom did not pull into the driveway at any time on that date, with or without Grayson. But had she come and brought him, that there were people home who would have received him. However, we believe that she simply didn't try. Dad has filed a motion to change domicile. Dad has no intent on changing domicile unless and until that motion is granted by this court. Until then, he intends to reside in Michigan. He knows what the law is. He understands what his obligations are. However, at this point, Grayson is still not home with Dad. We are requesting the immediate return of Grayson, and also that mom be held in contempt for violating this court's orders.
Okay, Ms. Smith, why has the child not been returned to the defendant at this point?
Your Honor, we have no proof that defendant is residing in the state of Michigan. And in regards of July 16th, mom did try to return the child. She actually witnessed one of the other children being returned back home. So she did try to return the child on July 16th. But until we are able to actually determine whether or not the defendant is in the state of Michigan, it would be in the best interest of the child to remain with mom.
Okay, there is no provision for those parenting time that the person reside in the state. Obviously, you cannot change domicile without court approval in this matter. The court is going to order that the child be returned this evening at 5:00 p.m. immediately at that time. If the child is not, the court would sign an order allowing the sheriff to go out and take custody of the child. So, Ms. Smith, you better advise your client accordingly, because I expect that to be followed.
Yes, sir, Your Honor.
Okay. The court will, in this matter, obviously there's some dispute as to the issues. She claims that she went. I guess that's subject to an evidentiary hearing, so the court would schedule the issue of contempt in for an evidentiary hearing. And apparently the defendant does have videos that would show whether she appeared as she alleges she did in her answers. So we'll schedule that. We'll contact both of your offices and schedule a hearing in this matter to address the contempt. So anything else, Ms. McNiff?
No, Your Honor. Thank you.
Okay, Ms. Smith?
No, Your Honor.
Okay. Court will end the matter at 9:51 a.m. You're free to go. Have plaintiff, Mr. Todd, on behalf of defendant. This matter is before the court on the plaintiff's motion to modify custody parenting time. Mr. Stupak. We can't hear. You're muted, Mr. Stupak. You have to unmute.
I'm sorry for you. In any event, we filed this petition. It's consistent, and I think counsel is correct in responding to this, that we have made several of these allegations before in our answer to, or our petition to set aside the prior order of the court. holding my client in contempt. But I would like to, and Mr. Todd seems to think that we have an alleged significant change in circumstances that would allow the court to address the issue of custody and parenting time. I believe that the fact that we alleged in our petition that the defendant has had very minimal contact with the minor child since March of 2021 is significant. He had court-ordered parenting time in an order that had been previously entered. Nevertheless, he waited until approximately 2 years later to try and enforce that parenting time, which is the subject of the contempt hearing. In addition, I would state that there is a significant arrearage that the defendant has. As a matter of fact, this court is going to conduct a hearing on Wednesday of this week to address that arrearage. That arrearage is approximately $9,600. He hasn't paid support in a few years. And to me, not providing support for the child is a significant change in circumstances that would allow the court to address custody, support, and parenting time. For those reasons, I think that we have set forth significant allegations that it would allow the court to consider adding this petition to be heard along with the petition to set aside the contempt proceedings that is set for September 22nd.
Okay, Mr. Todd.
Your Honor, I would disagree that there's good cause or a change in circumstances having a significant effect on the child. This is all a rehash what was previously brought to the court. And the court made a pragmatic decision and tapered some of Mr. Buzo's parenting time. The first visit he had was July 15th as ordered. That went well. And the court ordered another tapering parenting time. And then moving forward, Mr. Buzo would have his court-ordered parenting time. There has not been any allegation of a change really beyond that, outside of that which the plaintiff has controlled. Unfortunately, the plaintiff is the one who unilaterally prevented Mr. Buzo from exercising his parenting time. And we don't believe from a pragmatic standpoint, it makes sense to, in essence, award her for preventing that parenting time, preventing that communication. It is accurate that Mr. Buzo was divorced. That is a standard life change. We don't see any particular reason to move forward with any modification of parenting time outside of what the court has already ordered. Again, the court has determined that there would be some tapering issue and then simply move forward. Additionally, we don't believe that the fact that Mr. Buzo is behind in support previously has been sufficient for good cause or a change in circumstances to revisit custody or parenting time. Most notably, the Von Vargas standard requires that it shows an effect on the child. There really is no allegation about how any of these alleged changes would have any effect on the child. So we don't believe it's appropriate to move forward in terms of readdressing custody and parenting time beyond what's already going to be addressed at the hearing in front of the referee.
Thank you. Mr. Stupak, any reply?
Your Honor, the response from counsel is consistent with his client's position. That is, every time there's an allegation made that directs towards his ability to properly parent the child, they say it's my client's fault. I don't know. I'm not privy to the communications between the parties. I have information that indicates, for instance, in our petition that we had asked for information regarding the defendant's living arrangements, his work arrangements, what kind of provisions he has to provide for the child. And that would have been very easy in the answer to respond, but they throw that back on my client saying she never asked for it. Well, that's ridiculous. And I think we've certainly established enough cause for this to be included.
Okay. Well, at this point, the court has read the pleadings in this matter. The court does note that the court had previously addressed many of those issues in the prior hearings in this matter. The court does not I guess, observe or note that there's any substantial changes since the last order, which would meet the Von Barca threshold at this time. So the court is going to deny the motion at this point. Ask Mr. Todd that you would prepare the order denying the motion, and then you can proceed with your hearing on later with the referee in this particular case and address matters at that point. But the court doesn't find a basis for, again, modifying it at this time. So that will be the order, and the court will conclude this matter at 10:01 a.m. You're free to go. Have a good day. Note the appearance of Mr. Umloff on behalf of the, I guess, third party defendant or intervening defendant. I don't know what the, how she was designated in this matter. This matter is before the court on the defendant cross plaintiff's motion for modification of custody parenting time support, as well as grandparent parenting time. I was informed, Mr. Umloff, that you have an agreement in this matter. Is that correct?
And no, Your Honor. We initially reached an agreement in the guardianship case, as I outlined in my motion.
Okay.
That there would be grandparenting time on a week-on, week-off basis for the child, and that the guardianship would terminate. Unfortunately, when I prepared an order that I believed accurately reflected a resolution based on my subsequent discussions with Ms. Wilt and my client's discussions with the plaintiff, Brenda Wilson, I circulated proposed orders that I thought accurately reflected our resolution, but only my client signed them, which necessitated filing the instant motion.
Okay. Okay, so I guess we'll go to Mr. Wilson. What you're muted, so you're going to have to unmute.
Okay.
And what's your position in this matter?
He's represented by attorney on law.
Oh, you're represented by, okay, I had the parties wrong. Okay. It's Miss Wilk that we have to talk.
Wilson.
No, third party is Wilk, I thought.
Heather Wilt is not present.
Okay.
So we have Brenda Wilson.
Okay. Ms. Wilson, apparently that there was, Mr. Umloff says there was some sort of an agreement, but couldn't get the agreement signed. Is that accurate, or what's your position?
Yes, that's accurate.
Okay. Why couldn't we get that agreement signed?
Because I did another case with Mr. Onloff on another child. And then when I signed the agreement, then there was other stuff that we never mentioned in there in the case that allowed the other party to get other stuff that she shouldn't have got, which I was raising the child, and it all came in after the fact that I signed the paper.
Okay,
so I was nervous.
Let's address this case. I don't want to address another case that we don't have. So what's the problem with the order that he provided to you, which apparently reflected an agreement that was had?
I don't know why I didn't sign it, because I didn't trust him.
Well, did you read it?
Yes, I read it.
Okay. And what was in that order, what was agreed to previously?
That I get parenting time with Jason.
Okay. That's to be exercised. That was to be exercised in alternating weeks, correct?
Correct.
And was that your agreement?
Yes, that's the agreement.
Okay. Is there anything in the order that he sent to you that was not agreeable?
No.
Okay. Well, Mr. Umloff, it looks like you have an agreement as it relates to that order. So the court would ask that you would submit that to the court under 7-day notice of entry, as Ms. Wilson has acknowledged that that is the agreement between the parties and is acceptable, apparently. So
I can do that, Your Honor.
Okay, thank you. Submit it to the court. The court will enter it when we have that particular order.
Thank you, Your Honor.
Thank you. Thank you, everyone. And we'll end this matter at 1:08 a.m. Mr. Goldmarine, on behalf of the plaintiff, this matter is before the court on the plaintiff's motion to show cause. Court notes that in this matter that you do have a evidentiary hearing coming up before the referee tomorrow, I believe.
Yes, sir.
Okay. Mr. Vollmerine, previously when you were in court, the court noted that, again, there were multiple, show causes in this particular matter. The court would note that you could file those and they'd all be taken up for the referee. So what's the reason for being in court today?
I apologize, Your Honor. Can you repeat that? I was under the impression this would have been put in front of the referee. I wasn't, I guess I'm prepared to handle it today. I guess I would just,
no, what happens is I said that previously, I knew that there were ongoing complaints, ongoing motions. I said they'd all be heard by the referee. You could file those, but the referee would hear those. So I was just surprised when it came up on my schedule, knowing that you have a hearing tomorrow with the referee.
Yes, Your Honor. And this issue came up just a little bit ago. I did in my wherefore statement request that the referee hear this matter, because I do know that he's been really familiar with this case. But that's the reason why it wasn't combined with that hearing, as this is a recent development.
Okay. Well, what the court's going to do is there is that hearing. The court will allow you to address this matter at the hearing for tomorrow as well. You can take care of all of the show causes at the same time then.
Perfect. Thank you, Your Honor.
Thank you. Court will end this matter at 10:12 a.m. You're free to go. Have a good day and make sure that you come to the hearing tomorrow and get all these matters taken care of.
I texted Aaron and I just got a message back saying, what hearing?
Oh,
Did you say the hearing that the judge is waiting on for you?
I can.
Okay.
I'm gonna put you in the waiting room and hold on.
The phone number goes straight to voicemail for Schaefer's office. I left a voicemail and I sent him an email too. That's all.
All right, so I'll put you in the waiting room and we'll see what happens, okay?
Okay.
Court will note the appearance of Ms. McKenzie on behalf of the plaintiff. This matter is before the court on the plaintiff's notice for entry and settlement of order. Ms. McKenzie, what's the issue with regard to the entry of the order, or why can't we get it entered?
You can get it entered, Your Honor.
Okay.
And there have been no objections, so I'm asking the court to enter.
Okay.
The proposed order today dated, the order that was dated July 20th, 2023.
Ms. Perkins, what's your response?
Yes, Your Honor. I just have a couple concerns. On the first visit after our court order on July.
Ma'am, I'm not interested in the concerns. I'm interested in the order. What, if anything, is the issue with the order? Did the order comport with this court's prior ruling?
He did not. The first visit, he had me come pick her up early.
Your Honor, this is the same subterfuge. The issue is only, is the wording of the order accurate? Yes or no?
Okay. Yes, Ms. Perkins, I understand you're not an attorney, but when we have a notice up for entry, it's a matter, does the order comport with the court's prior ruling? If it does, you don't get a chance to rehash all of the reasons you didn't like the order or you thought the order was incorrect. It's just a matter, does it comport with the ruling?
I guess I don't quite understand what you're asking.
Well, Ms. McKenzie has provided you the order and she's noticed it up for entry. Is the order consistent with the court's prior ruling in this matter?
Yes.
Okay. The court will, at this particular point, as a result, court does note you have objections. And again, that goes to the issue of the initial dispute in this matter, but not to the order, is that you have not set forth any basis for the objection to the order and that it does comport with the court's prior ruling. The court will therefore enter the order as submitted by Ms. McKenzie in this matter. That will conclude this case at 10:16 a.m. You're free to go. Have a good day. On behalf of plaintiff, Mr. Bartel, on behalf of the defendant, this matter is before the court on the plaintiff's motion to compel. Mr. Bartel, Ms. McNiff just felt that she didn't want to go ahead without you because she just wanted to make sure that you were present.
Okay, I could tell the court, I do not see anywhere that I received this motion. And I'm trying to look through my email because I tend to get motions from Ms. McNiff's office from the email. So I'm trying to look through that and I don't see it.
That's accurate. She served it to your Hotmail account.
I do not. Do you know what the date was?
I do. It was July 20th.
I do not have that. I have an email from you on this regarding payroll checks, and that's all on July 20th.
Only thing I can think of is maybe it went to your spam.
I don't know.
Is that what you do, Mr. Bartel? You put on Ms. McNiff's email to spam?
I think my email actually has a threshold. After you have too many emails from one party, it sends it there, because I'm looking through it and I have about 50 emails in the last 3 weeks from Ms. McNiff and Carolyn.
Okay.
But not that motion.
And he hasn't filed a PPO against me yet.
Yeah, well, maybe he needs to. I don't know.
I may, especially when it gets into the weekends.
Okay. Mr. Bartel, this is basically a motion to compel, you file apparently objection to the subpoena. And so that's the issue before the court. I don't want to push you if you haven't had opportunity to review that. We can put it over or we can address it. What's your preference?
It was the
Well, Your
subpoena
Honor,
for the medical records, if that helps.
Yeah, and that's fine. We can go forward, Your Honor. I think, at least from my perspective, it's pretty straightforward as to this. And my understanding through text message that this is for an extension of discovery as well.
Well,
and I actually
only with regard to those medical records.
Okay, I guess I could tell you I'm in the middle of drafting a motion to actually extend discovery, because I got a lot of documents from plaintiff's side, and there's $35,000 that I'm still trying to track down. That went missing. I think I need some follow-up on that. That discovery ended on July 1st, if I'm not mistaken. We received the responses about a week later after that.
Okay.
So,
what's your response, Mr. Bartel, as it relates to the medical records? Apparently you've objected to that.
Yep. Yep.
Your argument is those are privileged. Is that correct?
Yeah, I mean, well, number one, my client doesn't have the records, and number two, my client, I think what's happening is that Ms. McNiff has served it on my client, so she cannot go to the hospital. I think her firm represents the hospital, so I think that's the reason why they served. My client doesn't have it, but more importantly, though, is we do believe that's privilege. It belongs to my client, and he does not waive that privilege. As I understand it from plaintiff's perspective, she says that he's an alcoholic. I understand it, but we've never denied that. We've actually, in our response initially in March of this year, we admitted that he's a recovering alcoholic. I don't know why she should get personal records that maybe he had conversations with certain people, whether it be a physician, to work through those issues. I think that is taking a step too far. He's admitted he's a recovering alcoholic. I don't know why they need any more information than that, other than him saying
maybe they just need more information as to the extent of it. All I can say, Mr. Bartel, your client has a right to assert his privilege pursuant to Michigan Court Rule 2.302 parens B parens 1 in this matter. But the court also, if he asserts that privilege, the court can consider that when the court looks under the Child Custody Act factor G as it relates to mental or physical health, and the court can, in fact, basically assume, if you would, or can infer that, in fact, that he would not comply, or that as a result of not complying, that in fact he would not be able to submit any testimony about that factor, and the court could, in fact, extrapolate that it would be held against him.
Do you mean not that factor at all, or just in relation to his, I guess, sobriety?
Well, the factor goes to the mental and physical health.
Mm-hmm.
Again, if he's not going to allow disclosure of documents or that relates to his mental or physical health, the court can infer, if you wouldn't extrapolate, that in fact he would, in fact, not prevail on that factor.
I guess my suggestion, Your Honor, is perhaps this court is willing to do an in-camera review, because as this court is, I think, aware that, sometimes there could be additional information that is not relevant to even that type of factor. I guess if the court, I would suggest the court to do an in-camera review. If the court's not willing to do that, then I guess if the court's position is that he either provide or sign off, I should say, on any of these records, or he would not be able to testify to it, I guess that is the order of the court then, and my client would have to make that decision then.
Okay, Ms. McNiff, you don't have the records, is that correct?
I don't have the records, and I know that I can't get them unless Mr. Clifton signs a release,
Right.
which is why I sent the subpoena to Mr. Bartel.
Court has no problem, Mr. Bartel, if you want to acquire those records, provide those to the court. The court would do it in camera review to see if there's other information that, again, doesn't pertain to, again, I guess you'd say any of the factors in the Child Custody Act, but principally the factor G.
Yeah.
And I have no objection to a protective order as well, that if in the event that there were documents that would be relevant that we could have if the court wanted to prohibit my client from seeing those records, I have no objection to that.
I think that'd be appropriate as well, because I know this court has done that in the past for counsel's eyes only, and that basically the counsel can still discuss the topic with their client in preparation of any hearing or trial.
Okay. Why don't, so that we, again, make sure that that complies with what you want to do, why don't, I'll have Mr. Bartel, I'll have you prepare the order, providing for the protective order, providing that obviously Ms. McNiff would get to review those documents following the court's in-camera review, then that's fine. What the court can do is I can delete and any particular, I guess you say any particular information that this court deems shouldn't be provided, but then the court could provide that back to both of the attorneys. So Mr. Bartel, you could see what I've again eliminated, if you would, or that I have deleted, and then we can provide that to Ms. McNiff as well.
Okay.
Great.
Ms. McNiff, do you have any problem with Mr. Bartel preparing that order?
No, not at all, Your Honor.
Okay. Well,
what about
go ahead and do that.
What about discovery, Your Honor? Are you open to extending discovery out until I would suggest like
until mediation, maybe?
At the end of this month? We have mediation, I believe, August 27th or 8th.
Why don't we do this? We'll extend out discovery until the date of mediation.
Okay.
And you can put that in the order as well, Mr. Bartel.
All right. Thank you, Your Honor.
Thank you.
Thank you.
All right.
We will conclude this matter at 10:26 with a motion for contempt in this matter as it relates to various property filed by the, well, I thought it was filed by the plaintiff, but is this filed by the defendant?
Yes, sir. That's correct.
Oh, okay. Go ahead, Mr. Lyle. I note that, again, let me ask this to the plaintiff. Ma'am, obviously, why have you not signed the documents so that he's able to do the refinancing?
Sir, I emailed you my response, and same thing I'm going to tell you right now. The paperwork that Mr. Lyerla sent to me for me to sign is incorrect. It has the wrong property description. It has the wrong township. It needs to be re-corrected, and then I will sign it.
Okay.
Same thing I told him, but he called me one day when I was at a funeral, asked me to sign it. I responded what I just told you, and I've never heard anything since until I was served last Thursday.
Okay. Mr. Lyerla, did you note that there's an error in the legal description?
This is the first I'm hearing of the legal description because all the warranty deed and everything I did investigation wise, all that information is correct. The property tax parcel, all that information is correct for the home that was awarded to me. So everything is correct on it. The paperwork I turned in the courts as well.
Well, the court's not going to do an investigation no matter what I'll do. Mr. Lyerla, obviously, if she believes the legal description is an error, you can check it, see if that's correct. And if you want to get it faster, you can, in fact, make the correction, send it to her. If not, what the court will do is the court will grant you an order conveying the property to you. So you'll have to do an order and submit that order under 7-day notice of entry. If you can get it in today, the court could sign it today. Otherwise, you'll have to notice it up for entry. Okay?
Once he corrects it, I'll meet with him and sign it. That's totally fine. But the township is incorrect and the property description is incorrect. The house is his. I have no claim to it. You want it in the divorce. I don't want it. Just correct the paperwork. I'll sign it.
Yeah. Your Honor, I don't know if I have to speak through you to Nicole. Nicole.
Go ahead, sir.
I'm just asking that. I guess I don't know what is wrong. What is she claiming that is wrong? Because
she claims first that the township is wrong, apparently.
On what piece, I guess on what evidence? That, is it the warranty deed that's wrong, or is it the quit claim?
Correct.
I guess I'm not sure.
Quit claim.
What,
The
the quit claim?
Your Honor, do you mind if I explain further?
Yep, go ahead. Go ahead.
Okay. According to our divorce agreement, and from all of my knowledge, based on the time we lived in the home is in Eckford Township. It is considered a mailing address of Marshall, Michigan, but the home is actually in Eckford Township. And the
Correct.
description you have of the property, and they may be typos, and I understand that. I see 3 or 4 numbers that are incorrect.
Which
Just
numbers?
by glancing at it. If you compare it to our divorce agreement, unless it was incorrect in the divorce agreement, which it may be, I don't know. It's something we have to find out. They don't match. The divorce agreement description and your description on the quitclaim deed do not match. Once it is corrected, I will sign it.
Okay.
So you
Well,
so you're saying you,
Go ahead.
sorry, Mr. Kirkham. So you're saying that you want the quitclaim deed to match the divorce agreement is what you're saying, right, Nicole?
I would recommend it, or else it doesn't do you no good.
Well, but ma'am, just in case, maybe the description in the judgment is in error. So
Correct. And
if it's an
I acknowledge
error, if that's an error, then whatever he submits to you, what he submits to you should be the correct legal, and that'll take care of it regardless of what the judgment says.
Right.
Correct. I do know the
yeah.
township is incorrect for sure. I do know that 100%. The legal description of your property, I do not know it 100%. I would recommend you verify it, and then I will sign it. I agree. It's possible it's wrong in the judgment. I do notice other errors in there, such as it leaves the divorce paperwork actually puts me responsible for the house because there's an error there. So I acknowledge there may be errors, and that's what I put in my response to this motion.
Okay, well,
But
all I'll say, Mr. Lyerla, is if you would check and make sure you have the correct legal description, you have the correct township, and make that change, and she'll sign it, she claims. So if she'll sign it, that's fine, and we've resolved the issue. If it subsequently turns out you've got the wrong legal, then that's your problem, Mr. Lyerla, but check it and make sure that it's correct, and she'll sign it. Once she signs it, she has no responsibility then.
Right. And that's why I was explaining to her in the divorce paperwork, it shows Eckford Township. In the quitclaim deed, it shows the same thing.
Okay.
I'm not seeing in the property description, everything has been transferred over based off of my research on this for the tax parcel ID and everything.
Check it and make sure that it's correct, provide it to her, and if she signs it, then she's done. She has no more responsibility to you at that point, so.
This has to be notarized, so can we exchange Olivia today? Nicole, can you do this today for me up in Battle Creek on her credit union? Because this has to be notarized. You can come in, do your part, and
time
then
for the notary.
Huh?
I can meet you after court on Friday. But I cannot,
But
I won't make it today in time.
I have to have this done today in order. This is why it was like a deadline of the last day of the month. I have to have this done today.
Well, you can bring it down at lunch at 12:30. I can meet you at 12:30 today at the County National Bank in Litchfield.
The County National, is that where you bank? Because it's not free to do it
Right
if you
across
don't.
the street from me at work, and I will pay for it. I will meet you there at 12:30. Are we good?
12:30 to sign off on this? Yes, I'd appreciate that.
Okay, great. Sounds like we have resolution. We'll end this matter at 10:40 a.m. You're free to go. Have a good day, and you can meet at 12:30 and get it taken care of. This matter is before the court on the defendant's motion to set aside referee recommendation. I've read that your objection, Mr. Black, and I understand you have some objections to what the referee did, but again, you have to show that the referee made a legal or factual error in this matter to set it aside. What is either the legal or the factual error that you believe the referee made?
The fact that she's allowing the person that I asked she's allowing the person that I asked to not be around our child to be supervised by the mother, but at the same time she said that she questions the mother's thought process. How can that actually contradicts itself on the process? Because she was like, she was like, it makes me question the mother's process that you would want to that you would want this to be around your child. But then she also allowed the mother to supervise plus, and then also allowed overnights. But how can you allow overnights with this person and you're asleep? How can you supervise somebody and you're asleep?
Okay. Well, clearly the referee did have a provision that, again, this individual should not be allowed around the child unsupervised, correct?
Correct.
Okay.
So if you're supervising, you can't supervise somebody and be asleep at the same time.
Well, you could supervise, let's say, for instance, the child and the plaintiff were in the same room, but this other individual was not. And let's say she locks the door, the child would then be supervised and safe. Isn't that correct?
Correct.
Okay.
But how do we know that that is the situation that would take place?
We don't know, and there's no way to know. I mean, if again,
So that situation. So I understand your honors, but that situation would be hypothetically, because there's no way to prove that that is what is taking place. So that situation right there would not be honorable either, because we cannot prove or deny what the plaintiff is doing. The plaintiff could say that that is happening, but that could not be happening, and then that still leaves the child in danger.
well, but in that, under your scenario, we can't affirm anything that might be a condition. So as a result, we don't do anything then?
No, as a result, I'm asking this right here. I'm not trying to, I'm not trying to stop the mother from being with this person. The mother, if the mother would like to be with this person, then she can be with him. All I'm asking is, if she wants to be with him and have him over at nights, bring the child to me, and I will watch the child. So then I know that our child is safe, because the child is in my house, in my household, where this person is at.
Okay. Miss Johnson, what's your response?
No. He had to leave his home to try to pick up the child since he was ordered.
Okay, ma'am, we can't hear you. It's really muffled. I don't know if it's a problem with your speaker or mic or whatever.
Okay. As I was saying, he wants me to drop Daniel off to him, but he hasn't even came to pick him up on his regular time already since it's been scheduled. I have still been having issues with him, getting angry and upset over this situation. And like I explained to him, that gentleman doesn't even stay at my house like that.
Okay.
The whole thing he said he don't care about being with him, but that's the problem. That is the problem. This is never going to end, because Daniel, he don't tell no one, but he tells me he wants me to come back to him.
Okay.
That's the whole issue.
We don't need to address that, because that's a non-issue.
But that's what I'm trying to explain to you guys. This is going to be an ongoing thing with this gentleman, because he don't want me to be with him. That's the whole point.
Okay. Ma'am, is there a problem if you are going to be with this particular individual, that in fact he could have the child with him if it's on an overnight basis, just if that person's spending an overnight with you or whatever it might be?
That's what I'm trying to explain to you, sir. No.
I didn't understand what you're saying.
I'm saying no. I do not want my son. I don't think you heard the recording of Daniel. Daniel has anger problems, and I don't trust my son with him.
You don't what?
I don't trust my son with him because he has anger issues.
Well, regardless of that, there's an order for parenting time, and so I'm not going to go back. I'm not going to go back and relitigate all of that.
And that's what I'm trying to tell you. He hasn't even gotten Daniel not one time since it's been.
Okay. Again, that's another issue. The only issue now, the only objection is this individual being around your son. So I don't want to rehash everything else and all the other complaints that the two of you have against each other. Just
that's what I'm
resolve
trying to
the issue of this person being around your son.
And that's what I'm trying to explain to you. He don't be around my son like that. We both work the same schedule, and when we're together, I'm with them. And if I'm asleep, that doesn't make sense to me. How am I going to watch someone when we're asleep? I got cameras in my house, if that helps anything.
Yeah. Well, and I guess that's what his issue is that he wants some guarantee that that person is not around your son. Maybe when you're sleeping. No, we lost her.
And Your Honor,
Nope, I want to stay with her and try to get her to respond.
yes, Your Honor.
Why? I'm not touching anything. It's just kicking me out.
Okay. Well, let's try to get a result. What he's saying is he doesn't want the chance that this particular individual is around the child unsupervised. And you're saying that we can do two things, say that this individual wouldn't be in the house at that particular point on an overnight basis, or that again, when the child is, when he is, that the son would go to the defendant.
When he's working nights.
Defendant is working nights?
I'll pay for a babysitter at my house.
That's the case, then my mom can watch him. And my mom stays right downstairs from me. And I trust my mom, then someone he's going to have to watch my child that I don't know.
Okay. So, Mr. Black, again, she's offered a hold on, stop. She's offered a compromise. It would say that, again, when this individual stays over, that your son would go and stay with her mother then.
Your Honor, and that's another thing. That's the thing.
Don't say it's a thing. Either give me a legitimate objection, or that's what I'm going to order.
I'm sorry, sir. There's a reason with that, because the mother lies, and they're going to be saying that he's down there, and then the mother is barely able to take care of herself right now. She's got heart issues.
Okay.
She's got to have people to come in and actually that's paid to come in and watch her and take care of her.
Okay, I don't know about that, but again, if the child is with her, if the person stays on an overnight basis, it should be easy to again get confirmation of that if that should happen. So what we'll do,
I have no contact with that person.
Okay, Mr. Black, what we're going to do is put a provision in place. You can state, in the event that this individual is spending the night with the plaintiff, that your son would go stay with her mother. And so you're going to have to prepare an order to that effect, sir.
I'm going to have to do what?
You have to prepare an order which, in fact, grants that relief. The court doesn't prepare orders for people, okay? You file the motion, so you have to prepare the order.
And to prepare this order, and the order is pertaining to what, sir?
The order would say that during the time that this individual, if the person should spend an overnight with the plaintiff, that the child would go stay with the plaintiff's mother.
I'm sorry about that.
Okay? Sir, you have to you prepare that order, submit it under 7-day notice of entry. If you're not certain how to prepare that, you can go to a service like michiganlegalhelp.org. If you submit it under a 7-day notice of entry and submit it within 7 days, then you don't have to do anything else. If you don't, you're going to have to notice it up for entry, which means you're going to have another hearing on a Monday.
Yes, sir. And okay, so what about the order of the fact that I only have that one, the part about I only have, like how she stated, I haven't been able to get my son since they gave the order because I'm being treated as a babysitter. But
I'm not getting into that. That's the order of the referee. We're addressing the issue of this person being unsupervised. So that order will remain in effect, and your order would modify that order.
And that's what I'm also trying to get modified. Also modifying the fact that the court only gave one person to pick my child up. One person.
Okay.
And that person they told me that I have to pick my child up to babysit him for the mother between the hours of 12 and 8 while she's at work. That one person they gave me only gets out. They get off at 3 o'clock in the afternoon.
Okay. Well, what you're going to have to do, that's not in your motion, sir, and I can't address stuff that's not in the motion.
That's the last thing about Crystal Montgomery. That's the last thing that I put in the motion.
Okay. Why don't you do this? The court will allow you to submit the name of an additional 3 people, submit that to the plaintiff, and then she can see if she has any objection with any of those 3 people picking up the child. then she can file an objection, okay? So include that in the order as well as to the 3 people that you would want to be able to pick the child up.
And that's it.
That's it. So,
And my other question before we close this, sir, how can I how can I get your ruling overturned?
you have to go to the Court of Appeals, sir.
Court of Appeals?
Yep.
And where do I come down to the courthouse to do that, to get the
Nope.
paperwork for that?
Nope. There's nothing down here at the courthouse that they'll give you to do that. You'll have to look up and find out how you're going to file a claim of appeal or application for leave to appeal. And you'll have to file those documents and take the matter to the Court of Appeals.
All right. Thank you, sir.
Okay, but get your order in because you can't appeal it until you have the final order, because that's the order you're appealing. So the Court of Appeals is going to want that order as it relates to your basis of appeal.
And what did you say that was again? What motions do I need to put in?
You don't file a motion, you file an order with the court. With what the relief is that I've already granted you. If you don't understand, this is on YouTube. You can listen to it again. I'm not going to keep going over it. So, okay, get the order in. You get it in within 7 days. The court can sign the order. And then once they sign it, then you can file your appeal. Okay, the court's going to end this matter at 10:58 a.m. You're free to go. Have a good day. Both of you. Ms. Hance, you filed a motion to extend the PPO. I note that the court does not yet have a proof of service in the file showing you served Mr. Hance. Did you in fact serve him?
The sheriff's department was paid to serve him. I'm not aware of whether or not they did or did not.
Okay, all right, Mr. Hance, you have to unmute. Did you in fact get service?
I actually did last week.
Okay, so we have service. It's just a matter of the proof of service have to check up or has to catch up. Ms. Hance, I'm going to take a little testimony from you. So if you would raise your right hand, we'll have you sworn in and then we'll proceed.
Ma'am, do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. And ma'am, tell me why the court should continue and extend the PPO.
Would you like me to keep my hand up?
Yes, yeah, take your hand down.
Okay, thank you. Over the course of the past year, when Floyd was on the current PPO, he actually I have 4 different police reports against him for violation of the PPO. There was one, in fact, violation that was with you, sir. On June 5th, he was violated for the PPO, and there was a 10-day deferred jail sentence pending. I also he's on probation for domestic violence. He is taking the DVIC courses, 52 weeks of the DVIC. His probation officer also violated him, Madeline Heisler, for violation of his probation.
Okay, I don't care about that. That doesn't affect the PPO. So I'm asking the court to extend for my protection. Unfortunately, I feel like Floyd continues to press the limits of communications with me and proximity to me. Okay. Well, Mr. Hance, I'll let you respond in this particular matter. There had been obviously some alleged violations, and in fact, you were found guilty of violating the PPO, have a deferred jail sentence. So why shouldn't the court extend the PPO?
Well, we are going through a divorce, and I honestly feel that it shouldn't be extended personally. There's been several times where I was there visiting with my kids, and she just gets out of her vehicle and then comes walking towards me. I mean, I honestly feel like she's not that scared of me. I mean, I have no intentions to do any harm. I want time with my kids. I mean, honestly, like ever since all this stuff started, I've never been able to express my feeling.
Okay, well, quite frankly, I'm more interested in compliance with the order. I don't care about your feelings, sir. So as long as everybody's complying with the order, that's all the court's concerned about.
Well, I do have, I am on probation. I've not been trying to do any violations at all. I mean, I'm wanting to get past all this, all this stuff. But I feel that, if the PPO gets extended, it could hinder, my time with my kids.
How would it happen? Because basically if it's extended, it said that you can't violate it and do what the PPO says you can't do.
Well, I promise you that I'm doing everything I can to make sure that I'm not trying to violate anything. In all honesty, all I want is peace. All I've wanted is peace between the two of us for our kids.
Okay.
I do want to say I work a lot of hours. I'm doing everything I possibly can to make sure that I don't lose any more time with my kids, or even I don't want to have any more conflicts. I will not do anything to hinder this anymore. In all sense, this whole situation has really took a toll on me, but all I want out of this is peace.
Okay.
The PPO brings me peace.
Okay. What the court will do is, I do note that the order expires on August 8, 2023. What the court's going to do is I am going to extend the order for an additional 6 months. I will put a provision in there, sir, that will state that, again, you can have, communication, et cetera, solely for purposes of court-ordered parenting time and for, those child-related issues. So if, let's say, the kids are with you and I don't know, they fall and get hurt, you got to take them to the hospital, you'd be able to call her for that purpose, and that's it. Likewise, you'd be able to call her to arrange parenting time if that needs to be done. But I will tell you, when that happens, I require that it be specific. You can't go off and talk about other things. You can't talk about, oh, I saw you doing this or I saw you doing that. You only address issues concerning the children.
Okay.
Sir, may I interject?
What, ma'am?
So we already have the Our Family Wizard. Our Family Wizard has been set up since.
Okay. Well, with that, then you should communicate through Our Family Wizard then.
And that is what we are doing. However,
Okay.
Macklin Heisler, his probation officer, has informed him that it is a view only on his part. He is to only view the things that I put on there, the events that I put on there. And it is arranged that he sees the children every other Sunday for 4 hours and
Okay.
every other Wednesday for 2.
Okay, well, all I'll say is the court's going to continue the order, comply with the order. You've got that set up so you shouldn't have any problems with communicating concerning the children, and that should take care of it. Anything else, Ms. Hance?
No, thank you.
Mr. Hance?
Yes, sir.
Okay, thank you.
Thank you.
Court will end this matter at 11:08.